This is an introduction to the Financial Planners and Advisors Code of Ethics. It will give you an overview of the 12 new standards for advisors, as well as the 5 values that underpin the Code of Ethics. The aim of this session is to introduce you to the Financial Planners and Advisors Code of Ethics, legislative instrument, the explanatory statement, as well as supporting information which is found on the FASEA website. We're hoping to demystify the 12 standards and the 5 values that make up the new Code of Ethics. As per the FASEA house diagram, which can be found on the FASEA website at fasea.gov.au. The diagram visually represents that the Code of Ethics forms the base or the foundation on which all other standards are built. Those standards being the naming of provisional provider, which essentially protects the term advisor or planner for people who are only qualified to call themselves such. The CPD or continuing professional development standards, which will ensure that advisors maintain their levels of competence. The exam standard, which will ensure that all advisors successfully complete a national exam. The foreign qualification standard, which allows advisors who hold foreign qualifications to have these assessed by FASEA towards meeting their education requirements. The education standard, which sets a new minimum in education for all advisors, both new and existing, as well as the work and training or professional year standard, which requires that all new entrants to the industry undergo 12 months of supervision before they are able to provide advice directly to clients. All of these standards are in the hope of delivering the outcome of better advice for Australians, also allowing consumers to hold more trust and confidence in the advice profession because of the raised education standards and the training and ethical standards that are imposed on financial advisors. A point to note is that, as is written in the legislative instrument for the Code of Ethics, this code imposes ethical duties that go above the requirements in the law. It is designed to encourage higher standards of behaviour and professionalism in the financial services industry. This quote and this section in the legislative instrument essentially is saying that the Code of Ethics is above the law. What this means is that there's primacy in adhering to the code, so that the code sits above and beyond the law. So we can't, as advisors, simply say, well, I've followed the law or I haven't done anything wrong or illegal. As you will see, the Code of Ethics will not only look at the law, but it does impose additional standards over and above the law. So I'll introduce you to the 5 values that underpin the FASEA Code of Ethics. Each of these values will be further explored in the coming slides. But trustworthiness, competence, honesty, fairness, and diligence. The simple definition for each of these is trustworthiness, acting in good faith with integrity and honesty in all professional dealings. Competence is having the knowledge, skills, and experience necessary to perform your obligations to each of your clients, clearly linked to ongoing CPD requirements, which we will uncover as we go through the standards. Honesty is maintaining complete integrity in all dealings with transparency, frankness, and fairness to each of your clients, even where this may cause you personal detriment. Again, an interesting one to look at, and we'll go through it as we step through the 12 standards. Fairness is maintaining professional objectivity when recommending products and services, and to investigate, evaluate, and diagnose a client's need for services. And diligence is using due care and skill, managing your time and resources to deliver services in a timely, efficient, and cost-effective way to each client. So let's begin our look into the 5 values that underpin the FASEA Code of Ethics. First, there's trustworthiness. FASEA define this as acting in good faith with integrity and honesty in all professional dealings. On the surface, it's pretty straightforward. But let's look further into trustworthiness. The dictionary definition of trustworthiness is the ability to be relied upon as honest or truthful. Another take on it is that the ability to accept without evidence or investigation. Many of you may be familiar with a book published in 2000 called The Trusted Advisor by David Meister, Green and Galford. In this particular book, trust, or a trust quotient, was depicted by a formula where C is credibility, R is reliability, and I is intimacy, and that is over self-orientation or self-interest. Essentially, in this model, it says that trustworthiness is created by having credibility. For instance, knowing what your capabilities are, being competent in your role. Reliability is the ability to fulfill your promises, to live up to your word. And intimacy is the ability for you to be able to make people feel comfortable. Your ability to have people open up and not feel that they're going to be judged or ridiculed. So these three components are contributors to being able to be trustworthy. All of these, however, are undone by acting selfishly or having too much self-orientation. Hence the formula being that credibility, reliability, and intimacy are the numerators and denominated by self-orientation. So if one comes across as being too pushy or too interested in their own outcomes, and this may be perceived or real, but if a client feels that you're only making a recommendation due to commissions, for example, then the self-orientation would be outweighing or taking away from any credibility, reliability, or intimacy that you've created with that client. Another definition, and a more recent one, through research in Australia by Dr. Michelle Cull and Sloan, indicates that specifically within the financial planning industry in Australia, that they've got 7 components that make up trustworthiness. These being vulnerability and risk, feelings, honesty, faith, best interests, accountability, and competence. So again, very similar to the models that we've seen, but just taking that a little bit further. But you can see there, it's not just tangible components. There's a lot of feeling and faith included in trustworthiness, making it quite an interesting topic to explore. From Sloan's research, Cull and Sloan's research, essentially trust is summed up as a trustee or the advisor can be relied upon to act honestly, competently, and in the best interests of their client, and thereby reduce the risk of loss for that client. The second value is that of competence. And competence is listed as having the knowledge, skills, and experience necessary to perform your obligations to each of your clients. If we look further into competence, the simple definition is the ability to do something well or the ability to do something efficiently or successfully. At this point, it's important to draw the distinction between competence and competency. To have a competence in something means you have a basic level or ability to complete a task. Essentially, you can do something at a pass level. To have competency is to be able to perform that task at a high level, but also understand the context within that, where that task may fit. So you have a broader understanding and knowledge of how to apply certain tasks. FASEA further explain the value of competence. They say, acting to demonstrate, realise and promote the value of competence requires you to have regard to the knowledge, skills and experience necessary to perform your professional obligations to each of your clients, I guess as we've seen above. But they go further to say it requires you to assess the professional services required by each client with regard to their individual needs, priorities, circumstances and preferences, expressed or implicitly identified, as the subject matter of the financial advisory engagement. While it may be possible to supplement your professional competence by accessing the expertise of others, the duty of competence is ultimately personal and cannot be outsourced to others. So this is where we look at potentially referring areas that are not in our expertise to other professionals. We still do have an obligation of competency here. So we must make sure that whomever we send a client to does in fact hold the competence for the task for which they're being referred. So competence is a deeper level of understanding not just the task at hand, but how that task will fit and assist that client achieve their broader goals. The next value is that of honesty. Honesty is listed as maintaining complete integrity in all dealings with transparency, frankness, and fairness to each of your clients, even where this may cause you personal detriment. The simple definition of honesty is telling the truth or able to be trusted and not likely to steal, cheat, or lie. It seems pretty straightforward on the surface. It's important when talking about honesty to look at the definition or the understanding of dishonesty. Because under the code, it's not necessary to establish that someone has been dishonest. The word honesty may comprehend conduct which is not criminal, but it's morally wrong in the commercial sense. We'll go through an example shortly, but just to expand on what FASEA have said under the value of honesty is they've said that it's acting to demonstrate, realize, and promote the value of honesty requires that you conduct yourself with complete integrity in all your professional dealings with your clients and with all others that you engage with in a professional setting. It requires transparency, frankness, and fairness to each of your clients, even where this may cause you personal detriment. An example of this might be where you have a client, an existing client of yours, so there's an established level of trust there, and this client comes to you. They have a portfolio of shares, for example, that they've been managing on their own or with a separate advisor. You personally may not be accredited to provide advice on direct equities. Now, this client comes to you saying that they would like to have guidance because their previous advisor is no longer with them. They would like to have guidance on how to invest these direct equities. Now, you may personally have an interest and a competence in direct equity trading, but of course you're not, your license doesn't allow you to personally provide that type of advice. So an ethical consideration here is, do you steer the client to not invest in direct equities because you're not accredited to do so? And do you guide them to add to their existing portfolio of managed funds for which you've advised them in the past? Or do you refer them on to another broker to manage that aspect of their portfolio? Again, there's no answer here, but just something to think about. So how would honesty play out in this? You're not being dishonest necessarily, but are you truly being honest in that type of a situation, depending on what your response is to the client? The fourth value is that of fairness. And that's listed as maintaining professional objectivity when recommending products and services and to investigate, evaluate, and diagnose a client's need for services. The dictionary definition of fairness is impartial and just treatment or behaviour without favouritism or discrimination. It's important to look at the fourth value together with the third, so fairness and honesty, because the word honesty, when used in conjunction with the word fairly, tends to give the flavour of a person who is not only dishonest, but also a person who is ethically sound. So you're being honest and you're being fair. They work together so that you're telling people the right things in their interests. So you're not just being honest, but you're also being fair. These two do work hand in hand. FASEA's broader explanation of fairness is to say that acting to demonstrate, realise and promote the values of fairness requires that you bring professional objectivity to the task of engaging with clients professionally. And when recommending financial products and professional services, it requires you to properly investigate, evaluate, and diagnose a client's need for professional services and to self-reflect on the limits of your professional competency. So a few questions are raised here, being, does the client genuinely need your service? Are you acting fairly by suggesting that they take up advice? So it's about self-reflecting and seeing, have I acted fairly and have I been honest with my client? And this is for each and every client in each and every advice situation. The fifth value is that of diligence. FASEA's simple definition is using due care and skill. Manage your time and resources to deliver services in a timely, efficient, and cost-effective way to each client. When we look up diligence in a dictionary, the simple definition is careful and using a lot of effort, or done in a careful and detailed way. On its own, diligence sounds pretty straightforward and self-explanatory. When we consider diligence, however, as a value, it very closely resembles what we otherwise would call a duty of care. In case law, a famous example is that ought to take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure someone affected by my act, that I ought to reasonably have them in contemplation as being so affected when I am directing my mind to the acts or omissions in question. Essentially saying that if we're going to do or not do something, we would be mindful of what effect our action or inaction would have on that person. So for example, with a client, if we disclose something, so be it a commission or what have you, obviously we do need to disclose commissions, but we know what the impact is of disclosing a particular dollar commission, what is the likely effect that will have on a client. Similarly, by not disclosing something, we also understand what the likely impact is to that client's situation. Under the requirements of diligence, there are three key areas. First is performing professional engagements with due care and skill. Okay, so being capable and competent, but careful, so showing that duty of care for our clients when engaging with them. The second is demonstrating efficient and cost-effective time management. So being capable and competent means that we're able to complete our tasks, complete our work, our professional obligations in a time-effective manner, and demonstrating efficient and cost-effective resource management as well. So that making sure that as advisors, ourselves and our practices work in an efficient manner so that costs, etc., are reasonable for the advice that's being provided. The new FASEA Code of Ethics is made up of 4 categories. They are the standards of ethical behaviour, the standards of client care, the standard of quality process, and the standards of professional commitment. An important thing to note is that these standards have been built on a principles-based system. Part of this is to ensure that the standards are not followed by a mechanical box-ticking approach, more so that these principles serve as guidelines to ensure that advisors are free thinking in how each of these standards would apply to different situations that arise. Let's go into them. Standard 1. You must act in accordance with all applicable laws, including this code, and try not to avoid or circumvent their intent. Standard 1 reads pretty straightforward. There shouldn't be too much interpretation taken into this one. However, let's look at the key areas of this standard. Not to avoid or circumvent their intent. So we need to look at what is the intention of the laws, but also what are the applicable laws that Standard 1 refers to. Are the applicable laws the laws that regulate advice, so laws such as the Corporations Act, anti-money laundering, counter-terrorism, privacy? Are these the laws that they're discussing? Or Are they the laws that are advised upon? So laws such as the Superannuation Act, sole purpose test that comes from that, the Tax Act, and so forth. If it is the laws that we advise upon, such as the sole purpose test, then superannuation has been designed for the sole purpose or their intention for retirement. So is it acting in the intention of the law to access money before preservation age? Should superannuation be used for the ancillary benefits of insurance? Is that acting with the intention of the law, or is that undermining the intention of the law? These are areas that have not yet been clarified, but should be forthcoming once the code monitoring bodies are in place. Standard 2. You must act with integrity and in the best interests of each of your clients. The focus here being on each client. But also, Standard 2 is the first standard that brings with it one of the values, acting with integrity. So let's look at integrity. If we remember, integrity is defined as openness, honesty, and frankness. If we further look into the explanatory statements from FASEA around the Code of Ethics Standard 2, point 32 in the explanatory statement says that to comply with the ethical duty, so the ethical duty here is integrity, it will not be enough for an advisor to limit their inquiries to the information provided by the client. An advisor will need to inquire more widely into their client's circumstances. So this brings scoping into question. When a client says, I would only like advice on one limited area, do we proceed with that advice or must we inquire? And if they don't provide us that information, what do we do? The other interesting point in the explanatory statements is point 34, again referring to the best interests that are referred to under Standard 2. Best interests, as quoted in the explanatory statement from FASEA, are not identical to the duty in section 961B of the Corporations Act. Okay, so it's not best interest duty as we know it. So the second part of point 34 says, so even if you follow the steps set out in section 961B of the Act, so if you follow the safe harbour steps, if you follow the best interest duty steps that are defined in the Act, you may still not have complied with the duty under this code to act in the client's best interests. So that raises a few questions, but also is in line with the intention of this code of ethics is not to have a tick box or a checklist mentality. It's about an advisor being able to use professional judgment and see, even though I have ticked the boxes for my best interest duty, have I still acted in this client's best interests? So for each of our clients, we need to consider, well, what happens if my clients get divorced? Am I acting in the best interests of each of my clients? Or does my relationship have to end with one of them? What about scoping? The scope of advice. My client has limited the scope to one area and says, I do not wish, so focusing possibly on insurance, but they do not want to disclose debts and cash flow to us. Can we provide that advice without knowing that further information? A key thing is Standard 2 does have an overflow with a couple of the standards that we'll be addressing shortly. Standards 5 and 6. Standard 5 is about ensuring the client understands the benefit and risks of the advice that we're providing. And Standard 6 is about the long-term effects of our advice. We'll explore these as we get to them. Standard 3. You must not advise, refer, or act in any other manner where you have a conflict of interest or duty. This, of all the standards, is probably the one that raises the most question. The key thing, you must not advise, refer, or act where a conflict of interest arises. So this principle of Standard 3 where you do not act, goes over and above the requirements in the law where you can disclose and proceed. So how does this impact us? Well, what are conflicts? Is charging a fee for service a conflict? Well, we believe not. If you meet standards 5, 7, and 9, which will be coming shortly as we work through the standards. However, to summarize these, standard 5 is ensuring that your clients understand the benefit and risks of the advice that they're being offered. Okay, so that's something that we already do. We need to obviously point out to a client how they are going to be in a better position as a result of the advice. So that should be no different to what we already do. Standard 7, consent must exist for all fees, and all fees are fair and reasonable and represent value. Well, we would hope that this has always been the case. So the client certainly would be consenting, as they would be signing off to an agreement. And the fees should be fair and reasonable for the advice and the value that they are presenting to the client. Standard 9, act in good faith with competence and not mislead or deceive. Once again, with all the disclosures and putting the client in the best position, our better position statements and so forth, all three of these standards should be being met. So the key thing to question is, where does the conflict arise? There are 3 example case studies at point 38 within the FASEA Code of Ethics explanatory statement. I'm not going to reproduce these on the screen, but I will walk you through the 3 standards. But I strongly recommend that you click on the link there of the FASEA Code of Ethics explanatory statement and download and read through this document if you haven't yet done so. But the 3 examples are, example 1, Harry recommends that his client, Fred, acquire a particular financial product. Harry's remuneration includes a bonus depending on the volume or value of that financial product that is sold. Harry's potential entitlement to the bonus creates a conflict of interest or duty, as it would reasonably appear to influence his advice to Fred. So that's pretty straightforward. If you get a volume bonus for any type of recommendation, then that is a conflict of interest and needs to be avoided. Example number 2, Sally has 2 long-term clients, Bill and Emily, a married couple. They tell Sally that they are divorcing. Because of the divorce, their interests will no longer be the same. If she were to continue to act for both of them, Sally's duty to Bill would conflict with her duty to Emily. So what does she do in this case? Does she keep one? Does she keep no clients? Again, the case study doesn't provide an answer, but certainly a discussion point. The 3rd example, George is a partner in a multi-partner advisory practice, where the partners have expertise in different areas. George does not have expertise in self-managed super funds, but Elaine, another one of the partners, does. Newman is a client of George's. George realizes that Newman needs advice in relation to a self-managed super fund. George refers Newman to Elaine, who competently advises him. Although both George and Elaine will benefit through the partnership from keeping Newman as a client, George does not have a direct conflict of interest, and the benefits both George and Elaine get do not flow from the referral, but from providing the advice to Newman. In fact, George has acted in Newman's best interest by enabling him to get competent advice. So these are 3 examples that FASEA have supplied to help uncover some of the conflicts that are referred to in Standard 3. But I encourage that you do have a further look through the explanatory statement, and as with all of these standards, we are still hoping on further clarification from FASEA and also from the code monitoring bodies once they are announced. Moving on to Standard 4, the first of the client care standards. The standard states, you may act for a client only with the client's free, prior and informed consent. If required, in the case of an existing client, the consent should be obtained as soon as practicable after this code commences. If we look into this standard, the key points to note are the free, prior and informed consent, as well as for existing clients that the consent needs to be obtained or re-obtained from a client. Let's look into the first component, informed consent. Under the FASEA explanatory statement for the Code of Ethics, point 41 gives us 3 items that must be included in that informed consent. The client must be consenting to what services will be provided, the terms on which they will be provided, and the records that will be made of the services and the privacy and confidentiality arrangements applicable to them. So these are the things that the client is making free, prior and informed consent about. For existing clients, of course, they would have consented to the advice in the original piece of advice. However, under the new code, all clients will need to re-consent after the code starts. So we would think from a practical perspective, it's not that on the 1st of January, all clients need to re-consent, but it would be when it's practical. So we would expect that this would be at the next interaction, next point of advice, possibly at the client's review or when fee disclosure statements are being sent out to the client. So at the next reasonable opportunity or practical opportunity that arises for each client. A useful link is supplied at the bottom of the page here. It refers to the AFCA approach to adequacy of statements of advice, because AFCA have said or come up with 8 questions that they use to determine that a statement of advice is adequate. And these 8 questions really are testing whether the information contained within an SOA is clear and concise. Essentially, is it something that a client would understand? Because if they understand it, then we could deem that that client has been informed. If you've told a client but they don't understand what they're agreeing to, then that client arguably is not informed. So the 8 questions that AFCA used to test this situation are: number 1, did the financial firm consider the client's experience, language skills, literacy and numeracy? So was the documentation pitched at an appropriate level for that client? Number 2, did the SOA use language the client was likely to understand? Self-explanatory. Question 3, did the SOA use legal, industry or technical language? So once again, was it language the client would understand? And this obviously will vary from client to client. Was the information in the SOA in a logical sequence? If the information logically flows, it's more likely that it is understood and therefore more likely that the client is informed when giving their consent. Number 5, did the SOA identify the client's objectives in quantitative terms and explain how the advice would achieve those objectives? So once again, this is nothing new for us, but this comes back to explicitly writing goals that are specific, measurable, achievable, realistic and time-bound. So does the client quantify terms for does the document quantify terms for that client? So for example, rather than saying they want to retire comfortably, we've defined what that is. So the client to retire at age 60 with sufficient savings to generate a retirement income of $40,000 a year is a lot clearer than saying a comfortable retirement. Question 6 from AFCA is, does the SOA resolve any internal conflicts? By this they mean that if a client says that they want to be invested in low risk, yet the recommendations put them in a balanced or a riskier portfolio, how has this conflict been addressed in this statement of advice? Once again, this comes back to our documentation, and in that type of example, there would have been a trade-off discussion that needs to be referenced and documented. Did this statement of advice contain irrelevant information? So if it's a risk-only SOA, does it include information on other areas? Because if it does, then those irrelevant areas are only distracting from the focus of the advice. And question 8, is the SOA a template document? Because in AFCA's experience, they've seen that highly templated statements of advice more often than not lead to standard text and lead to the lower likelihood that a client is going to understand that text. So again, being mindful and careful of tailoring advice documents for each client appropriate to that client's literacy level. Standard 5. All advice and financial product recommendations that you give to a client must be in the best interests of the client and appropriate to the client's individual circumstances. That doesn't sound like anything too different to what we're already used to with best interest duty, but let's continue. You must be satisfied that the client understands your advice and the benefits, costs, and risks of the financial products that you recommend, and you must have reasonable grounds to be satisfied. So this takes best interest duty just that little bit further. But also Standard 5, as mentioned earlier, ties in further explanation on Standard 2, which was to act with integrity and in the client's best interest, as well as Standard 3 with the conflicts of interest. So let's explore Standard 5 a bit further. The key points to note are that under Standard 5, you must be satisfied that the client understands your advice. So that's something a little bit different. We've always had to explain it clearly and concisely. We've always had to have plain language in our statements of advice. But this, under client care, means that as the advisor, we must be satisfied the client understands our advice. So once again, this will come back down to our record keeping. How have we documented that we have some level of satisfaction that the client understood what our advice was? Not only the advice, but the benefits, the costs, and the risks. And how do we have reasonable grounds for this level of satisfaction? Let's look into it. Reasonable grounds to be satisfied. Well, you must have reasonable grounds, i.e. some evidence. So we've got to have something on file. We've got to have, again, file notes that will show that we are satisfied that the client understands our advice, the benefits, the costs, and the risks. As I've said over and over, it is about file noting. So it's not to say that these aren't anything that we're not already doing. It's just that we may not be clearly file noting. And under this obligation, we now need to make sure that our file documents why we are comfortable that the client has understood what the advice is. I would expect that ways to do this would be to show how things were explained. Don't just have a short note there to say, explain to client, client agreed, we proceeded. But showing, were there diagrams that you used? Were there scribbles? Do you take a photo of the whiteboard that was used to explain to a client, or have you scribbled on a notepad? All of these personalized explanations, these scribbles, these ideas, these diagrams, they should all be retained on the client file because they will show personalized evidence that that concept was explained to that client in terms that that client would understand. And even if it was explained and re-explained, all those scribbles will certainly build an argument and build a case to show that there was a personalized, detailed discussion to ensure that client understood the concept. And of course, these diagrams would be similar across some clients, but there would certainly be personalizing factors. So if you're showing volatility, don't just show a blank volatility chart, but insert dollar values that personalize that volatility to what the client could expect, using their account balances on the visual to show a 10% decline for one client might be $20,000, a 10% decline for another client might be $90,000. So showing those values will certainly go a long way to demonstrating you've explained it, but also that the client has understood it in terms that relate to them. The key thing is you want to have proof that explanations were in a language that the client and that each client understands. So it's not going to be a one-size-fits-all explanation. Further information, once again, is in the explanatory statement for the Code of Ethics. So point 46 talks about these four elements: being satisfied that the client understands the advice, the benefits, the costs, and the risks. Once again, this sounds a lot like your better position statement. So it's about drawing out those examples and that information and making sure that it's expressed in a way that the client would understand. Let's relink how Standard 5 links back to Standard 2. And Standard 2 being act with integrity and in the client's best interests. So by our obligations under Standard 5, which is to explain things in a clear, concise manner in a way that the client would understand, but also by having our own reasonable grounds to our level of satisfaction that the client has understood the advice, we are also meeting Standard 2 or going towards contributing to Standard 2, which is acting in the client's best interests, because it's in their best interests that they understand the advice. And by having evidence on file that demonstrates how we've clearly explained not only the advice, but the benefits, the costs, and the risks of that advice to a client, it's showing how the client is making an informed choice, and also, as per our advice, it is putting a client into a better position, it is acting in the client's best interests. We are bringing all of these components, which I guess there's nothing really new there other than making sure that we have documented that we have a reasonable grounds for the satisfaction that that client has understood. So that is how Standard 2 and Standard 5 are linked. If we go further and look at Standard 3, which was the avoid any conflicts, again, by adding that layer of Standard 5, making sure the client is very clear and understands not just the advice, but the costs, the benefits, the risks. It's allowing that client to make an informed choice, and it would also be free of conflicts because the client is fully aware of everything. So it's not just about disclosing conflicts. Obviously, we're avoiding conflicts, but by making all information known, it does remove conflicts because the client is in an informed position. On its own, it doesn't get there, but we've got other standards that will continue to build on this. So we can now see that there is a link between Standard 5, Standard 3, and Standard 2. Standard 6 states, you must take into account the broad effects arising from the client acting on your advice and actively consider the client's broader long-term interests and likely circumstances. The key points to note here are the broad effects arising from the client's acting on your advice and the broader long-term interests and likely circumstances. So this goes a little bit beyond what we've seen previously. Standard 6 is all about needing to look at the broader effect of our advice, not just the immediate impact. So one of the things to consider is insurance inside super. It's a cost benefit today, but it has an erosion of retirement benefits and a tax liability at claim for non-dependent children. So the benefit today might be eroded by a detriment tomorrow. Another example could be the potential for aged care funding provisions for a client or family member. If we know the client's situation where they have an elderly parent living with them, or what if through our discussions with our clients we know that their adult child is about to go through a relationship breakdown, would that person be coming back in and into the family household, potentially threatening the retirement savings or becoming a dependent once again? Are there substance abuse issues, gambling issues in the family that also need to be factored in? So are these broader effects and part of the family unit, are these now things that must be considered? Explanatory statement points 49 and 50 do talk broader about these. Point 49 says, this standard expressly requires you to take into account the broad effects of the client acting on your advice. These effects are not limited to effect on the client. For example, your advice may have implications not just for the client personally, but also for other family members of the client. These will need to be taken into account, although you will not have a duty to act in the best interest of the family members if they are not clients of you or your principal.
You will also need to consider whether your product recommendations should be limited to ethical or responsible investments. So looking at the client's broad situation, other types of investments, something that should be considered for them. But the broader family situation is something that should be factored into the advice. We can't just turn a blind eye to situations that we become aware of, because they will have a longer impact on the client. Point 50. This standard expressly requires you to take into account the broader long-term interests and likely circumstances of your client. Reflecting on Section 961B of the Corporations Act, for example, any potential need for the client or one of the client's family members to move into aged care accommodation in the near future would need to be factored into any financial advice you give the client. So again, looking at the broader effects and the longer term effects and the likely circumstances of the client's situation that we're aware of, these all need to be factored into the standards of client care, in particular Standard 6. But as mentioned earlier, Standard 6 does link back to Standard 2, which was acting with integrity and in the client's best interests, because looking at their broader situation, not just the scope of advice that was initially requested by the client, but if we are aware of longer term implications or flow-on effects of the advice, these must be considered. And Standard 5, ensuring clients understand the benefits and the risks of the advice. So once again, demonstrating and showing the longer term and broader implications of the advice links into this standard of standard number 6. Standard 7, the first of the quality process standards. And when we think of quality processes, we're talking about processes that are designed to deliver to the client's end expectation. So it's about delivering useful advice to a client. Standard 7 states, the client must give free and informed consent to all benefits you and your principal will receive in connection with acting for the client, including any fees for services that may be charged. If required, in the case of an existing client, the consent should be obtained as soon as practical after this code commences, which is 1st of January 2020. Except where expressly permitted by the Corporations Act, you may not receive any benefits in connection with acting for a client that derive from a third party other than your principal. You must satisfy yourself that any fees and charges that the client must pay to you or your principal, and any benefits that you or your principal receive in connection with acting for the client, are fair and reasonable and represent value for money for the client. There's a lot in this standard, but if we break it down, the first component that we'll look at is free and informed consent. Now, we spoke about informed consent back at Standard 4, and there was an explanatory statement reference at point 41. So we're not going to revisit that exact content, but one thing we will extend upon is to reinforce that within the Royal Commission findings, and in particular the fees for no service, it was found, and Commissioner Hayne specifically mentioned, that due to the lack of consent from clients in signing up for fee-for-service agreements, that the fee for no service issues arose. So by explicitly having this as one of the Code of Ethics standards, free and informed consent, it would be directly impacting the issue or potential issue of fees for no service if a client has expressly given their consent. Next, fair and reasonable. Now, the term fair and reasonable has not been specifically defined in this code, but is a term that does get used a lot in a legal sense. So it's all about balancing things up, and can essentially be summed up in that next point there being representing value for money for the client. So value for money, if we focus on that, one of the definitions could be the total lifetime benefit less the total lifetime cost. Let's use insurance as an example of this, where the lifetime of holding an insurance policy, there certainly is a cost. There's a cost, an ongoing cost of annual premiums, and there would have been a cost for the initial advice offered to place that insurance. There is also a lifetime benefit. So for the period which that policy is held, there is a benefit of peace of mind, the client having some reassurance that if something happened, that they're going to be covered. But of course, there is also a benefit in the event of a claim. So with insurance, there is benefit whether or not the client claims. It's just whether there's a tangible benefit or an intangible benefit. So another way of looking at value for money is weighing up the fees or the costs of something versus both the tangible and intangible benefits, as we've just mentioned. Now with Standard 7, there are links, as we've already established with Standard 4, but links to Standard 3, which looks at the conflicts. So Standard 7 is not saying that you're acting in a conflicted way, but Standard 3, conflicts of interest are less likely to occur if there is free and informed consent occurring with a piece of advice. Standard 4 we've already spoken about, which is free and informed consent. And Standard 5 looks at understanding advice benefits, costs, and risks as well. So again, the client is consenting to all of the advice. So they're consenting to not just the advice, but the benefits of the advice, and they're also aware of the costs and the risks of that advice. Standard 8. You must ensure that your records of clients, including former clients, are kept in a form that is complete and accurate. Under Standard 8, there is nothing really new compared to the existing legislative framework, but one of the things that it does mention there is complete and accurate records. There is no specific definition of what complete and accurate records would constitute. However, this draws our attention to one of the other findings in the Royal Commission was that poor records were very closely linked to the fees for no service, whereas businesses that didn't have a strong record keeping process were found they were unable to identify the clients who had or had not signed up to ongoing agreements, or essentially there was not sufficient evidence on file to substantiate whether a client was or was not agreeing to ongoing fees. So that's one of the things being addressed under this standard. One call out, of course, is the focus on former clients as well. Obviously, all clients need to have their files maintained and privacy upheld and so forth. But in the case of former clients, they're the ones that sometimes get left behind or are forgotten about. So we need to make sure that all clients, both former and existing clients, have their files maintained and up to date. Standard 9. All advice you give and all products you recommend to a client must be offered in good faith and with competence and be neither misleading nor deceptive. Under Standard 9, there are a few components, the first of which is good faith. The explanatory statements at point 58 define good faith as acting honestly and in the best interests of the client in giving the advice and making the recommendations. This definition links itself very closely to Standard 6, where we need to factor in the broader and the longer term effects of any advice that we give. Therefore, to meet the obligation of good faith under Standard 9, we need to be acting honestly, we need to be acting in the client's best interests, but we also need to be factoring in the broader and the longer term effects of any advice that we give. The second component of Standard 9 is that of competence. And competence, if you remember back, is one of the underlying values that underpin the whole code of ethics. And competence was earlier defined as having the knowledge, skills, and expertise necessary to perform your obligations to each of your clients. So this is about making sure that we maintain our level of proficiency and competence with the advice that we're giving. The third component is misleading nor deceptive. So the words misleading and deceptive exist in Corporations Act. We already have
a legal framework around the terms misleading and deceptive, and there are no changes to our requirements in this space. So under Standard 9, we need to act in good faith with competence and not mislead or deceive our clients. Standard 9 links itself very closely to Standard 3, which is around the conflict of interest, Standard 5, which is about the client understanding the advice, the benefits, the costs and the risks, as well as Standard 7, which is about the client giving free consent and the advice being fair and reasonable and value for money for our clients. Standard 10, the first of the professional commitment standards. You must develop, maintain and apply a high level of relevant knowledge and skills. This is probably the most straightforward of the 12 standards in the Code of Ethics, where this is simply about meeting your higher education requirements and maintaining your annual CPD requirements in all of the CPD categories, that being client care, the regulatory requirements, technical, as well as professionalism and ethics. Standard 11. You must cooperate with ASIC and monitoring bodies in any investigation of a breach or potential breach of this code. Pretty straightforward. Standard 12. Individually and in cooperation with peers, you must uphold and promote the ethical standards of the profession and hold each other accountable for the protection of the public interest. Standard 12 brings with it 3 responsibilities. The first, to uphold and promote the profession at a personal level. Second, to hold each other accountable. So to call out non-compliance, essentially be a whistleblower if you see the wrong thing happening. It's a bystander responsibility. And third is for those experienced advisors who are taking on a new provisional advisor to actively assist the provisional financial planners as they enter the profession. This has been an introduction to the new FASEA Code of Ethics, with the 5 values that underpin the code, as well as the 12 standards